Welcome, everyone. My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We are blessed once again to have our partners at the North Texas Fair Housing Center here, namely Francis Espinoza, the executive director, here to talk about eviction, what you need to know. One of the things I want to point out as we get started is that it looked like most of the people I saw that are joining us from Texas, but we're going to be today's webinar is going to be based off the Texas rules about eviction. So if you're in other states and you're joining us, please know that the laws are different from state to state in regards to eviction. But if we could move to the next slide, Francis, and then I'm going to talk about CEUs and then we'll get going. For those of you that are joining us today that are wishing to receive CEUs or even a certificate of attendance, for today's webinar, we're offering CEUs, complimentary CEUs for licensed social workers and licensed professional counselors that are licensed in the state of Texas. If you have a different license in Texas, or you have one of these licenses or any license outside of Texas, you're more than welcome to go through the process and get a certificate. But please note, there's no guarantee they're going to take it, and we have there's no way we can help you with trying to get them to accept that, because these are the two we're set up with. But you're more than welcome to get it, submit it. I've had people tell me they've gotten them taken, but that is totally up to the jurisdiction that manages your licensing renewal process. So today's webinar is worth 1.5 hours of CEU credits. In order to qualify, you must have completed the entire live webinar. That means that we get a report off of Zoom that tells us how many minutes you were on for. And if you get kicked off and you log back on, it's okay. It'll give us several reports under your name, and we just add those minutes up. But if you're joining us by phone, just so you know, the phone number will show up on the report, but it won't give us any correlating information of who it is. It just gives us a phone number. So if you're joining us just by phone, please send me an email after today's webinar letting me know the name and email address associated with the phone number you're joining us from. The other thing is, if you're joining us together with someone else, please note you really need to be logged in under your own name, because that's the only way it shows up on the report, and we have to have that report as backup documentation that you did join the webinar. And so you really need to show up on there individually, not being in under somebody else's name. Okay, you must complete the Google. You also must complete the Google survey. And there should be a pop-up right as you close out of Zoom today that lets you go there. But if not, you'll receive the link in a follow-up email from me today or tomorrow morning that will have that information in it. Plus, it will have information on a whole bunch of upcoming webinars and that type of thing. If you give me you have a week to complete the survey. Once that is done, then I'll send out the CEU certificates. I do it all at once. And that's why we put the deadline on it, is because I just don't have the manpower to do the surveys one at a time. We have a kind of a system set up that just spits them all out at once. So we certainly appreciate you joining us, and I'm going to turn it over to Francis Espinoza. And Francis, again, is the executive director of the North Texas Fair Housing Center. I'm sorry. Francis, I'm turning it over to you.
Okay, thank you, Marty. Can everybody hear me okay? I'm just checking my volume, make sure it's good for everybody.
It's good now. It was a little light for a second, but now it sounds good to me. If you guys have any issues, make sure you put it in the chat, please. And once again, if you have any questions, actually, once again, I didn't say this. Please put them either in the chat or the Q&A. We won't be. We have a lot of people on, so we won't be calling on people to open up their mics. Thank you so much.
Okay, but as we go through or at the end, we'll try to answer the questions that come in through the chat. So if you have a question, please put it in the chat. So today I want to cover the eviction process because at my agency, the North Texas Fair Housing Center, we are getting an awful lot of calls about evictions. And so I thought it would be helpful to folks to know step by step what they can expect and what is part of the process for eviction. Okay, so I want to start off by talking about leases because a lease is a binding contract, and I think sometimes people don't see it that way. But when it all comes down to it, it's a contract that you've signed, a commitment, and it could be for 6 months, 12 months, 18 months, whatever the tenant and the housing provider agree to. And leases typically cover a lot of issues. And what you need to know about Texas is that there aren't a lot of laws for the state that deal with the landlord-tenant relationship. And so many times when people have an issue in their housing, they really need to refer back to the lease to find out what their rights are. And it's just, that's where Texas is a very pro-landlord state. And so there's a lot more laws that are protective of the housing provider and not the tenant. So be aware of that when you sign a lease. And never sign a lease without reviewing it first, and don't feel bad if you have to take some time to review it and read it thoroughly, because you really should read all of those things. That way you're not surprised later about how they handle parking, for example, or the fact that there's a monthly trash fee so that they can come by your apartment and pick up your trash, and you can't opt out of it. So even if you feel like you can take your own trash to the dumpster, you're still going to have to pay that fee if it's in the lease and you sign the lease. So just make sure you read everything thoroughly. So other topics that are covered in a lease: late fees, non-payment of rent and what happens with that, evictions. There'll likely be a provision in your lease regarding when late fees start accruing. Some start accruing right after the rent is due. So your rent's due on the 1st, but maybe on the 2nd, you start accruing a late fee. Some apartments give you from the 1st to the 3rd to pay rent. So, make sure you look at that term of the lease. And if the housing provider has to start eviction proceedings, a lot of times they shift the cost of those eviction proceedings to the tenant. So the tenant will then be liable for not only, any unpaid rent, if that's the reason for the eviction, but they'll have to pay the attorney's fees for the housing provider. So just make sure that you thoroughly read that lease and understand what you're signing. And the reason for that is, the consequences of breaking a lease. The housing provider can put an eviction on your record if they go through the court process and get an eviction against you. If you have unpaid rent, they typically have a collections agency they work with, and they could pursue you to collect that rent, and they can put that unpaid rent as a debt on your credit report, something that will pop up the next time that you go look for an apartment and your background gets checked, or your credit gets checked. Okay, so I've been getting a lot of calls lately about leases, and people are upset that their lease is not going to be renewed. And it's at the complete discretion of the housing provider as to whether or not they want to renew your lease. And so the only exception to that is if you live in affordable housing, housing that takes your income into consideration when they set your rental amount, or any apartment buildings or multifamily housing that was built with tax credits or any kind of government funding. They have different rules, and they specifically can only decide to not renew a lease if there's been a major breach of the lease that would be defined before the person signs the lease. So if you're in regular market rate housing, the housing provider can decide not to renew your lease, for whatever reason they want, and they don't even have to tell you what the reason is. They can just give you a notification that they're not gonna renew your lease. The only other exception to that is they can't base their non-renewal on discrimination. But if, they don't have to tell you what the reason is, it's really difficult to prove that they've based their decision on discrimination. A lot of what we're hearing lately is that, folks make repair requests or other complaints, and the housing provider is upset with the tenant and as retaliation decides not to renew the lease. Now that is retaliation, but that's, a difficult case for a tenant to bring because they would have to bring it in court and prove it. And that process takes time. And in the meantime, your lease could run out. And so just, be aware of that, retaliation is not a valid reason to not renew your lease, but there's no government agency or administrative body that could step in and say, okay, you have to renew this lease. You can't decide to not renew it for this reason. So, you're kind of left with even if it is based on a bad reason, you still may have to leave, and you could pursue your remedies in small claims court or justice of the peace court, they call it here in Texas, after you've moved out. Okay. So I want to do just kind of a nutshell overview of the eviction process, but then I want to go step by step into each of these things. So an eviction is a breach by the tenant. What we're seeing right now is a lot of the evictions are based on unpaid rent, and that typically is the most common reason for a tenant to be evicted. There could be evictions based on other breaches of the lease, like maybe somebody's just being way too noisy and they've gotten warnings. And, the apartment may have a process of, we'll give you 2 warnings and the third one, we're just going to give you an eviction. But most typically what we're seeing is evictions based on non-payment of rent. And it doesn't necessarily mean that the tenant could never come up with the rent. If you miss the deadline to pay your rent, whether it's the 1st or between the 1st and the 3rd, even if you can come up with the rent on the 5th, the housing provider still has the right to evict you for paying your rent late. And also for paying, if you try to make a partial payment, they can also evict you for that, because they can say, the part of the payment, the rent payment that's not paid, that they can use that to evict you or to file an eviction. So the first thing that usually happens is the tenant has to be served a notice to vacate. And for non-payment of rent, that's usually a notice that tells you you have to move out in 3 days. And if you don't do that, then after that notice expires, the housing provider can file an eviction in court. So the tenant doesn't move, so then the eviction gets filed in court. And evictions are heard in the justice of the peace court in whatever area that you live in. There's a hearing, and then after the hearing, depending on what happens, if the tenant loses, the judge issues a writ of possession, meaning you're given a date of when you have to move out. And there is also an appeals process that I'll talk about too. Okay, so let's talk about the notice to vacate. There is a law in Texas that talks about the notice to vacate, and that's Texas Property Code 24.005. Now, the notice to vacate is required before a landlord can file an eviction, but know that if they don't give you this notice, they could still file an eviction, because the judge won't look at the issue of whether they filed or whether they gave you a notice to vacate until you actually go to court and have the hearing. But keep that in mind, because if you don't get the proper notice to vacate and the housing provider goes directly and files the eviction, if you raise that issue in court, the judge should dismiss the case because the landlord didn't follow the proper procedure. So the notice will, like I said, give the tenant 3 days to move, unless your lease states otherwise, but typically it's 3 days to move out. And there's other requirements about the notice and how it has to be delivered that are in the Texas Property Code. And so any of these things, if the housing provider doesn't do that, you need to keep a record of that, because if you raise this issue in court, the judge should dismiss the case. So the notice has to be delivered to someone in the household who's 15 years or older. It can be delivered by certified mail. The housing provider can also deliver it by putting it on the inside of your door, so they can enter your unit and tape it onto the inside of the door. They could put it on the outside of the door, but a dangerous situation has to exist for them to be able to do that. And if they put it on the outside of the door, it should be in a closed envelope with the tenant's name and address. And a copy of it must be mailed to the tenant the same day it was left on the door. So if, say, the housing provider put it on the outside of the door, but didn't put it in an envelope, just like taped it up to the outside of the door and didn't mail you a copy, those are issues that you could raise in court and hopefully get the eviction dismissed. So those are all things, we call those are defenses at the eviction hearing, which really they're not defenses as much as they are the housing provider didn't follow the proper procedure. The law goes step by step in what they have to do and gives them requirements. And if they don't meet any of those, you have to raise that in court in order for the eviction to be dismissed. And if it is dismissed for one of those reasons, be aware that the housing provider will probably remedy that issue and file again as soon as they can. Okay, so then the next step is the eviction filing. So the landlord has to wait until that 3-day notice expires. So if you get a notice on the 4th day after you get it, so say you get it on a Monday, so the 3 days are Monday, so the day you get it counts, Monday, Tuesday, Wednesday. The 4th day is Thursday, and that's the first day that they could file an eviction, following the process, following the rules of eviction. Weekends do count. So, if they file, if they give you the 3-day notice to quit on a Friday, Mondays, so Friday, Saturday, Sunday, Monday's the 4th day. So Saturdays and Sundays count. So don't discount those. And count holidays too, because most courts, they don't skip holidays when they count the days for these types of requirements. So anytime you get a notice, count the day it comes, and then 2nd day, 3rd day, and know that on the 4th day, if you don't move, if you're not out of there, they could file an eviction. So the eviction is filed with the justice of the peace court. It's called JP court here in Texas. If you're from another state, it might be called small claims court. They hear small claims, and usually small claims in the same courts that they hear evictions. So there's a lot of pieces of information that the filing must have. It has to have your address, an apartment number, a description of the facts or the grounds for eviction. And that is a little more important if you're being evicted for another breach of the lease, like the noise issue. It's a very simple description if you're being evicted because of unpaid rent. They also have to put the total amount of rent due if the reason for eviction is non-payment. So they have to total that rent and say what it's for. They also have to put in their attorney's fees if that's what they're seeking, even if it did say so in your lease that if they file an eviction, you have to pay their attorney's fees. They have to itemize that in the filing, otherwise they can't recover it. And all adults that are on the lease must be served. So, say it's you and your partner that live in the apartment, but when they file the eviction, they only put it in your name, and your partner's also signed the lease and is on the lease and is part of the lease and is a tenant, you could raise that issue in court and hopefully get it dismissed because they need to file and serve all the adults on the lease. Okay, so this is an example of what that filing is going to look like and what you would get served. So you're going to get served something that looks similar to this, that has a court date on it. You know, it has the date. Some stuff here has been redacted, but up where you see on the upper right-hand corner, they itemize the rent that was due 508.65. There'll be a docket number, and that's just for the court to keep track. Or if you ever want to get a copy of this, you know, later, the docket number is a good thing to have. And then if you go below that, it's signed by the court and it has the date that it was filed on there. And then there'll be information on here of your court date. That's below that. If you see the word, it's kind of blacked out under it, but it says set. And then there's a line there. They'll set a court date for when you have to appear, and make sure that you do appear, because if you don't appear, there'll be an automatic judgment for the housing provider. Okay. Okay, so let's talk about the hearing. So the citation that you get served is going to list the date and time, like I said before. And the court date is usually between 10 and 21 days after the landlord files. Now, this could vary. Like, for example, this varied a lot during COVID because courts weren't seeing people in person and had to start doing everything over Zoom or whatever virtual program they used. And also, you know, it could take a longer time if the court's impacted with a lot of evictions. You could file an answer before the hearing. So, for example, if you are being evicted because of a noise issue, you could file your response to that and why you feel that, you know, it wasn't valid for whatever reason you feel that it wasn't. If it's non-payment of rent, really the only thing that you can respond is if you were able to gather the rent. That's after it was due or after the 3-day notice expired. That's a good thing to list because, you know, the court might take that into consideration if you come to your hearing date and you have the funds to be able to pay anything that you owe in rent. Now, it isn't required of the judge to consider that. The judge doesn't have to force the housing provider to take that so that you can remain in your housing, but, you know, it doesn't hurt to try if you're able. So the hearing, again, it's your time to tell your side to the judge or jury. And most typically it's going to be the judge unless you ask for a jury trial for the eviction. And then another court date will be set for that because they have to go through the jury process and call jurors to appear. But most times it'll be in front of the judge, and, you know, you got to tell your story and bring anything that you think will help, any proof that you think will help. Like I said, if you're behind in rent and you were able to gather those funds, that's a good thing to bring to court and to tell the judge that you are able to get current with your rent. And again, if you don't show up to your court date, automatic default judgment for the housing provider. Okay, so let's talk about possible defenses. And I raised these issues a little bit in the earlier slide about the 3-day notice. So say the notice is defective, they didn't serve it right, they didn't put it on the inside of your door, or say your 10-year-old answered the door and they gave it to your 10-year-old. They can't do that. The person that gets served has to be 15 or older. So failure to comply with contractual or other notice requirements, So say no notice was even given. You didn't get any 3-day notice. You just got the service from the court telling you that you had an eviction filed against you and when your court date was. If it wasn't preceded by a 3-day notice, that's defective. So you need to raise that issue in court for the judge to consider it. Improperly delivered, like I said, say your 10-year-old answered the door, that's not proper notice. And if you have a housing choice voucher, the housing authority has to be notified of both the 3-day notice and the eviction. And so if the housing authority wasn't notified, that could be defective notice. Say they did give you the 3-day notice and it was valid. They served it the right way. They taped it on the inside of your door or handed it to you personally when you answered the door. But they filed the eviction on day 3 instead of day 4, or day 2 instead of day 4. They have to let the 3 days pass before they can file. So you can raise that issue in court, and that's defective. So again, anytime the housing provider didn't follow the rules, the judge should dismiss the case. And then, as a last ditch effort, and retaliation by the landlord, you can raise those issues, but, be aware that, like I said, Texas is very pro housing, pro landowner state, so pro housing provider. So, the judge isn't necessarily gonna hear anything you have to say. Even if you have the best case, I have to warn you that, a judge may not care. And so you need to be aware of politically kind of the landscape of, what Texas, kind of the state of politics in Texas, right? Who gets, these judges get appointed to the bench by people who are elected, who don't necessarily, they weren't elected on the platform of housing rights. And so, you need to be aware of that. Retaliation is an issue at your eviction hearing you could raise. So say the housing provider, you feel that the housing provider filed the eviction solely because you are making a lot of repair requests because your apartment is in disrepair and there's a lot of things that need to be done. You can raise that issue in court as a defense. And you should have all of your repair requests if you can. I know a lot of apartments now do repair requests through the portal. But always keep copies of things for yourself. So if there's a way to do a print off the portal, or if you get like a confirmation, print that screen or save it as a PDF, or when that screen is up that shows proof that you filed the repair, take a photo of it with your camera of the computer screen. You just got to make sure that you have enough evidence to show the judge if you're going to claim retaliation. And then, of course, last ditch effort, if the eviction was filed for non-payment of rent, if you were able to gather those funds and, get caught up, tell the judge that, show the judge, you have the money right here and you're willing, you're willing to pay your rent because you want to stay living where you're living. And maybe the judge will consider that and force the housing provider to take your rent and dismiss the eviction. It doesn't ever hurt to try these things, right? So, these are all things that you can do or issues you can raise once you get to the eviction. Okay, so after the judge makes the decision, either side can appeal the decision. So, like I said before, if the tenant wins, typically the housing provider doesn't go through the appeal process. What they'll typically do is fix whatever the reason was that they lost and refile the eviction. They won't appeal the decision that was already made. The housing provider will usually just, if they, gave a defective notice and didn't follow the rules, they'll redo that portion and then refile the eviction. They usually won't go through that appeal process. Now for the tenant, if they want to appeal, the tenant has to do that within 5 days of the judgment. So say you go to court today and there's a judgment today, it's Tuesday. So I would count today. So Tuesday, Wednesday, Thursday, Friday, Saturday, it falls on a Saturday. So I would file my appeal by Friday to be safe. So you need to file a bond, make a cash deposit, or file a statement of inability to pay within 5 days of the judgment. If it's a non-payment of rent case, the tenant must pay 1 month of rent into the court registry within 5 days of filing the appeal. So the inability to pay, which was the line above, that's the inability to pay for the appeal process, because there's always a filing fee. Now, if it's a non-payment of rent, you will have to figure out how to pay 1 month of rent into the court registry with the appeal. After the appeal is done, that means that case is going to go to the next higher court. So that's going to be like a district court, a county court, and they'll rehear the entire case. So it's another chance for you to make your case and tell the judge what maybe was missed in the initial eviction hearing. Now, if the tenant doesn't appeal within those 5 days, then the landlord can go back to court and get an order from the court on the 6th day. And that's a constable order with a date of when the tenant will be removed or can be removed from the premises. So the way that works is the constable, if they show up at your door, they should have an order in their hand that shows that that's the date, and any date after that they can physically remove you, meaning they tell you to leave and you really can only take as much as you can carry with you. You'd have to make arrangements to get your other belongings if you still have some in the apartment, and you have to leave the premises at that time. Some constables, they go to the apartment some days ahead of the actual order date to give the tenant warning, but that isn't required. So a constable could just show up one day with a court order, and it's your right to ask to see that court order saying that you have to get out. And that's the only way you can actually physically be removed from an apartment or from a rental. Okay, so what are the ways of avoiding eviction? Some local jurisdictions, and I mean cities, might have ordinances. I know the city, for example, of Dallas is, I don't know if it's a temporary ordinance right now or if it's become permanent, but they actually have added additional rules for housing providers that they have to try to work out. If it's an eviction for any reason, they have to talk to the tenant and try to work things out. If it's non-payment of rent, that would be some sort of payment plan. If it's another issue, they have to try to work that out. But there aren't many jurisdictions that have it. So we're just going to be left with whatever the state requires. So you can always talk to your landlord and try to resolve things. And anytime you do that, you want to put things in writing. So say that you're going to pay your rent late this month, and you go talk to the manager or landlord and tell them that, you won't have the rent by the 3rd when it's due, but you will have the rent on the 7th or the 5th or whatever date, and try to work that out with them that they'll accept the late payment. If they do, have them put that in writing, because if they just verbally tell you that they're going to accept it late, you don't have any proof of that, if they file the eviction on the 4th, because rent was due from the 1st to the 3rd, or they give you a notice to vacate on the 4th, you will not have any defense. It's really hard to prove a verbal agreement. So you want to make sure anything you agree to with the landlord, that gets put in writing. Always keep documents to show that you did pay your rent. A lot, I know a lot of apartments go through a portal now, so you should, if it's a portal, I think it's typically debited from your checking account. So you would have your bank statements to show proof that you paid rent if you can't get that kind of ledger out of the portal. And you can also contact us, the North Texas Fair Housing Center, to learn about your rights. And also contact legal aid in your area. Typically they have clinics for eviction. And if you have an eviction filed against you, you can go to one of their clinics and they'll help you do the answer and respond, and go through the process with you. It's really rare, though. I'll tell you, it's very rare that legal aid will represent somebody in the Justice of the Peace Court. They just don't have enough staff to be able to do that. So going to the clinic will just help you be better prepared to go to court and represent yourself. Okay, so let's do a quick quiz. So which of the following, and you can write your answer or type your answer in the chat. So which of the following is not a valid reason for an eviction? There might be more than one answer. So what is not a valid reason for an eviction? Is it non-payment of rent? Violation of a non-smoking clause in your lease? The tenant asked for a reasonable accommodation? Or the tenant allows someone else to move in? What do you guys think? Okay. Yes. Yes, looks like we're getting a lot of C's, and C is the right answer. You should not be evicted for asking for a reasonable accommodation. Now, keep in mind that, like I said, there's no administrative entity, governing body, that if you ask for an accommodation and the housing provider retaliates and tries to evict you for that, there isn't anything that's going to stop that process. So you still need to go through the process, but that's something you raise in court, that you are asserting your rights under the Fair Housing Act to ask for an accommodation, and the housing provider didn't like it, so they evicted you. They started the eviction proceeding. So you still need to, if the eviction's filed, because you asked for an accommodation doesn't make that eviction go away. You still have to go through the process and raise your defense in court. So let's talk about the other ones. Of course, non-payment of rent, that's a valid reason. Violation of a no smoking clause, that is a valid reason. It's a breach of your lease, so that's a valid reason. If you live at a building that has in your lease, it's a no smoking property, and they smell smoke coming out of your unit, then they could file an eviction for that reason. Typically that's, there's going to be a warning before that, but they could file an eviction because of that reason. They still have to tell you, give you 3 days to, they have to give you a 3-day notice to move, and follow the process with the steps of the eviction, but that's a valid reason for eviction. And then someone did put D in the chat, so I wanted to go over that one. If the tenant allows someone else to move in, so that's an unauthorized occupant. So that could be grounds for eviction if the lease is in your name and you sign the lease and it's just you living there, and then you allowed somebody to move in with you without going through the proper channels, meaning you have to make the request of the housing provider that you want someone to move in with you, and you're gonna have to add them to your lease. So you have to go through those procedures. Otherwise, you could get evicted for that because you have an unauthorized occupant. Now, that's for an adult that moves in with you. Excuse me. If a child moves in with you, you need to give the housing provider notice, but that cannot be a reason for eviction. If, say, I had a case recently where a grandma had to take custody of her 3 grandchildren, and she was in a 1-bedroom, which is small for having an adult and 3 children, but the kids were, 2 were, I think, 3 years old, 2 or 3 years old, and 1 was only months old, like maybe 6 months old. And so, those are little kids, and a 1-bedroom probably isn't going to be such a big deal until the kids get bigger. But the housing provider was trying to evict her because the housing provider said, we told you when you moved in here, we don't allow more than 2 people in a 1-bedroom. And so the North Texas Fair Housing Center got involved in that case, and we were able to get them to drop the eviction proceeding because they were violating the Fair Housing Act and the familial status protection specifically, which protects people with children under the age of 18. And this, in my case, the grandma she had legal custody. She took legal custody of her grandkids. And so she had all her paperwork in order that, she was now their legal guardian. And so for adding kids to the household, you can't be evicted. Okay. One more quiz question. So what is the first step in the eviction process? Is it A, the landlord files in court? B, the landlord warns the tenant that they may be evicted? C, a court date? Or D, the tenant receives a notice to vacate? Okay, yay. We're getting all the right answers. So D, that's the first step in the eviction process. The tenant receives the notice to vacate. And again, the notice to vacate, like we talked about before, it has to follow all the other rules of how it's served and who it's served to. If the landlord does any of the other things first, like immediately files in court or verbally warns the tenant that they may be evicted, that's not proper notice. Or you get a court date. In all of those cases, you still have to go to court if they filed eviction, but you raise the issue that you never got notice of the eviction. And a verbal warning is not a proper notice, or a verbal, even if it's more than a warning and it's a verbal notice, like you need to get out in 3 days because of whatever reason, or I'm going to evict you. The verbal notice is not meeting the requirements of the law. They need to give you that notice in writing. So that's something that you can raise in court, and the eviction should be dismissed. Now, the reason I use should all the time when I say the judge should dismiss it is, again, sometimes judges don't follow the rules either. And you just need to be aware of that it's not 100%. Never when you go to court is it 100% that it's going to turn out the way it should. Okay. Marty, do you want to see if there's any questions? Should we see if there's any questions before you go over the CEUs again?
Hold on, just I'm trying to check the time. Go ahead and yeah, there's a lot of questions. And because you asked for answers, there's a lot of scrolling to do to get to.
Oh yeah, I'm not on the Q&A. I'm going through the chat right now to see if anybody dropped it in the chat.
There's 4 very good ones in the Q&A, or 5, I guess 5 now.
Okay,
but
I'm just quickly scrolling through the chat to see if I could see any. I think everyone might probably put them in the Q&A. So
no, there are several in the chat as well.
Is there? Okay.
Yeah. There's someone that asked. I'm gonna read off these while you're looking through there if I could.
Sure.
How long does the entire eviction process take in Texas or North Texas?
So it can be as short as 10 days, it can be as long as 21 days, but there are a lot of other, that's just a generalization. There are a lot of other factors. Like if the court's just inundated with evictions, it's going to take longer. Okay, so, you look at, and that's just to get the court hearing. So first you have the 3-day notice. Okay, then the eviction gets filed. And that's the part that your court date might be in 10 days, it might be in 21 days. Okay, so now we're talking about that added to the 3 days. And then if you lose, if you appeal, that's going to draw the process out even more, because remember, you have to file that appeal within 5 days of the initial judgment, but then it has to go to another court for a hearing. You'll get a notice of the hearing date for that from that court, and then that hearing has to take place. And then there's if you don't file within the 5 days for an appeal, then the housing provider can get an order from the court to physically remove you by a constable. But that date's going to be in the future too. I don't know how long it takes them, because, I think they only have, I don't know if all the constables share in that duty of eviction, or if it's just a handful. I'm not sure. But that takes, the housing provider has to get the judge's order, and then that there's a date set that the constable goes out. So, that'll lengthen the process if you don't file an appeal. If you file an appeal, you're going to have to go through that whole second court process. The appeal, you're going to have to go through the appeal court. And then if you lose again as the tenant, then this housing provider still has to get an order from that court allowing them to get a constable to physically remove you. So, it really depends on, if you file the appeal or if you don't file the appeal, and how impacted the courts are to get you these court dates.
What?
Because I think, I don't know about the court, I don't know about the county courts for the appeals. But my guess is right now, I've been getting so many calls for evictions, and I'm probably not the only one. Probably a lot of nonprofits in North Texas are getting these calls. So the courts might be a little bit inundated right now with evictions. So it may take longer. So that's kind of, the timeline there.
Yeah, and then when the constable comes out, usually the constable's there to keep the peace. Usually someone else is actually there to remove the property, and they usually they can just put it on the curb. Is that right?
I have to look at the Texas law, because there may be some provisions that they cannot do that. They may have to store it. There might be requirements that they have to store it. And it's actually not legal for them to throw it out on the streets, but I need to look that up. Because I just had a case like that, but they were asking me things about it, and it was a commercial property. So the residential property rules didn't apply there, but I remember reviewing those residential property rules, and I think it's illegal for them to throw your property out on the curb. But a lot of them do that. They just don't care. But there is a process they're supposed to go through to store your belongings, and then you have to go, reimburse them for the storage costs before you can get your stuff back. But if that's something, I can respond to that later, Marty, and
okay,
maybe you can get that into if I
yeah,
do it quick enough, maybe you can get it into your email.
I don't know how quick you can check into that, but if you can check into that, somebody just put storing property is not required, which sure sounds like it, especially in Texas with the landlord friendly laws, it sure sounds like they but if you could check on that, I'll try to wait for you to send out the first follow-up email and see if I can include that answer in there. If I don't know what your day looks like, but go ahead.
Okay, and I'm still scrolling through
You
the
guys,
chat.
and just so you know, the link again, Francis was saying, there's several pieces to this that she spelled out in the timeline. The length varies, and right now it probably varies greatly from from court to court just because of a backlog, because we are absolutely inundated with these calls. And I know everybody else I've talked to in this industry is the same. So that could vary. But the other one I'll read to you. Do you want to go ahead and answer one, or do you want me to keep reading them?
Yeah, you can keep reading them. I'm
Okay.
ready.
So one of them is, if a person received a notice to vacate within 3 days and they leave the property within the time frame, do they still need to go to court for an eviction?
So if you get out within the 3-day notice period, the housing provider should not file an eviction. That doesn't mean they won't file a collection if you owed rent. And so just be aware of that. They might put something on your credit report if you left owing money. But if you get out within those 3 days, they should not file an eviction. So, that's something that, if they do file an eviction, you would have to appear in court and raise that issue to get it dismissed. But they should not. That's the whole purpose of the 3-day notice, is they want you out for some breach of the lease or for non-payment. You get out. So you don't owe, the only thing that happens after that is not an eviction, but they can pursue you for unpaid rent or anything else you owed them.
Someone asked, a failure to wait 3 days before filing the notice is based on what initial date? Is it the first day of when they're late? So the 3-day notice, the filing of the 3-day notice, I mean, they can give you a 3-day notice on the day after the first day your rent's late, right, Francis?
Yeah. So if your rent, according to your lease, if your rent's due on the 1st and you only get the 1st to pay it and it's late after that, they can give you a notice to quit on the 2nd. If you do have a grace period, say between the 1st and the 3rd, then, and you don't pay rent, they can give you the notice to vacate on the 4th. They don't have to do that though. Anytime from the 4th and on, they can give you that 3-day notice. So say that, it's the 1st of the 3rd, but, they waited until the 5th. And then on the 6th day, they gave you the notice. It doesn't matter as long as it's after the rent was due. So the clock starts ticking on that 3-day notice. The date it's given to you is day 1, and then the next day and the next day. So day 1 is the date they give it to you. Then there's day 2, day 3. Then they can file the eviction on day 4. And they're just later than they're just doing it later than they could have. But that's, that's their decision.
And one of the biggest misunderstandings we see is people that don't understand that, when the landlord gives them the 3-day notice to vacate, that's it, that it's all over then. And there's quite a process after that. Obviously, they go file, the landlord has to go file in court and wait, and you got to get the court date. But so many people panic at the 3 days, and please note the process is quite a bit longer than that. But the process requires that the landlord give that 3-day notice before they can go to the judge to file for the eviction through court. So.
Yeah, and it's for example, in paying your rent isn't, getting current and paying your rent isn't necessarily going to stop that process. Like say you get the 3-day notice, and on the 3rd day of the notice, you are able to borrow money from a friend and you go to the housing provider and, hey, I can pay now, and they don't care and they don't accept it. And then they file eviction the next day. They're within their rights to do that. So it's really unfortunate because, like, for example, in California, they do have a 3-day notice, the same 3-day notice process, but their 3-day notice is called a 3-day notice to quit or pay. So if you pay within those 3 days, nothing happens. You're fine. You stay there, no evictions filed. Because that's what the notice is. It's like you have 3 days to either get out or pay us. But here in Texas, it's just you have 3 days to get out, and we don't care if you were able to get the money together during those 3 days.
And
So just,
and
it's
and
unfortunate.
even if they accept that rent, they can still go on with the eviction, right? Because you were late.
They can, but you have a good issue to raise in court to the judge, and it'll probably get dismissed because technically, once they accept that rent, it should void the eviction.
Um,
That's why a lot of times, even if you're able to get the rent together within those 3 days, they won't take it. And the reason they won't take it is because they want to file an eviction, and they know if they take the rent and then file an eviction, technically, if they accept the rent, you're not in breach anymore.
yeah.
So you raise that issue in court, like, hey, I was late, but I paid my rent and the late fees, and the judge should dismiss the eviction.
Someone asked, through the eviction process, can the tenant remain in the apartment?
Yes. That's why only the constable can come and ask you to get out and supervise you as you get out, and then lock the unit up after you. Because no one else is allowed to remove you from the property. So yes, you can live there the whole time this process is moving. The only time you have to leave is if the landlord gets the order from the constable, and then the constable comes and throws you out.
Um, Mindy asked, what do you do if you've paid the landlord the past due rent, but they don't release the judgment?
So if the eviction hasn't happened yet, then you've paid the rent, but you should still go to court to make sure the judge dismisses that, to say, that to tell the court that you paid and show your proof of payment. I'm not sure if the question was a release as in, you've gone through the whole eviction process and you owed rent, because we have that issue pop up too with people where, they call us because they aren't being, their applications to rent are being rejected because in their background, it shows that they owed a previous landlord at some time in the past 5 years. They owe, like, I don't know, $1,200, and it's, still on their record. So in order to get that off your record, you have to go back to that apartment and work things out and try to figure out why they have that on their books. And if you need to pay it with, written confirmation from them, and don't pay without getting that written confirmation. That is going to get removed from your credit report, or some letter that you can use to get it removed from your credit report. So I'm not sure if the
It
question
is
was.
it is never a good idea to pay your landlord cash and not get, or even pay your landlord and not get a written receipt from them and of some type. Now, I know a lot
Right.
of people. I'm sorry.
Oh yeah, no, you're right. I mean, if these days it's like so many apartments have portals, and so you're
Yeah,
going to get it directly taken from your checking account. Um, or if you write a check, you're going to have access to that account, the check after it processes through your account from your bank. But yeah, I would never pay rent in cash without getting a receipt.
yeah. Anything you pay to your landlord, you need to get a receipt for and hold on to it. Just because there are, there obviously are unscrupulous people in every industry, and I know this can be the same. And you need to have every proof. Your word um, doesn't go very far in court. I mean, you can say you've done whatever, and they can say they did, and their word against your word is it really doesn't work very well. Um, okay, do you want to go ahead and address some of them that you're seeing?
Yeah, I'm not really, I think this person needs to contact me because I'm not
Yeah,
really, I need
yes,
to
yeah,
I need
I
to
totally
research
agree.
that a
I
little
read through
bit.
that too, and I kind of got lost in it a little bit as well. So I will um
Because I actually think in this situation, they didn't necessarily need to dismiss the eviction because of the divorce proceeding. Because if both, it doesn't, divorced or not divorced, if both of their names were on the lease agreement,
Yeah.
that can move forward. I mean, I think this judge just made a discretionary decision to
Yeah.
dismiss that and have them deal with their divorce first.
Yeah. Cheryl,
Because
Cheryl, if you could
technically,
reach out.
even if they get divorced and one moves out, if their name's still on the lease, I mean,
Yeah.
they are still financially liable for that lease.
Yeah. There's a lot of other questions, and this one's really complicated. So, Cheryl, you'll have uh, uh, both my and Francis's contact information in the follow-up email. If you reach out to her and go over that, that would be very helpful. Um, for those of you that asked about the electronic version, I put it in the chat. I also put it in the email that will go out following today's thing. Yes.
So adding my email to the chat just in case. So yeah, if the person about the divorce wants to review that with me, give me a call.
Yeah.
I think that's some rare instance that,
yeah.
Probably not very common.
And Christy, yes, we already answered that question, but yes, the tenant is allowed to stay in the apartment through the eviction process.
So here's another question, and I'm kind of going backwards now through the chat. The person said, I understand that an eviction can be made if an unauthorized adult moves in, but what if a pet moves in? That would be legal grounds for eviction if you didn't go through the proper channels to ask to add a pet. Because a lot of apartments are going to have pet rent or pet deposit. And so you want to, get permission to add a pet to the household before you do it. That's ideal. And so once you do that, they can add an addendum to your lease that it's a pet. Even if it's a emotional support animal for someone with a disability, and they need a reasonable accommodation to add an ESA or emotional support animal to the lease, they should still, ideally, they should still follow that same process. Let the housing provider know they're adding, they need to add an ESA to the household because that's an accommodation request. And then the housing provider has the right to ask for verification of that, doctor's note or some medical professional's letter saying that that is prescribed for the person. And then, you might still have to add an addendum that there's an animal there, but you shouldn't, in that case, if it's an ESA, you shouldn't have to pay any pet rent or pet deposit. But just be careful doing that without going through the proper channels first, because, we do get a lot of people calling us that they've added an emotional support animal, but didn't go through the proper notification to the landlord before they did it. And then we kind of have to work backwards from there. So always ideal to, go through all the process of getting the permissions first.
Somebody asked, what requires the PHA, the Public Housing Authority, to be notified of a 3-day notice and filing?
So the housing authority should be notified in the same pattern that the tenant is notified. So sometimes though, with the housing authority, they might even give the housing authority a heads up before they do what they're going to do. But definitely if they serve that 3-day notice, they need to also inform the housing authority that they're giving that 3-day notice to the tenant. And then, that way the housing authority can do whatever they need to do, because, presumably they're paying their portion of the rent. And if only the tenant's not paying theirs, housing authority needs to know.
Someone put in here, Deanna put in here that since Texas is a pro-landlord state, this is when you may want to request a jury trial. But does the jury you still there's still have to abide by the same landlord friendly laws that the state um, has, right? The judge has to educate the jury on what the law is, correct?
Yeah, they have to make their decision according to law, but I think having jurors, they can maybe have more sympathy for the person and maybe not follow the law like they're supposed to. Um, so most times people ask for a jury. Honestly, most people ask for a jury to lengthen the time that they can stay in the apartment, because if you go to your hearing and you don't want the judge to hear and make a decision, and you have to ask for a jury trial, and that takes, like I said, that takes more time, because the courts have to draw a jury to hear your case. And so that's going to lengthen the time frame that it takes for everything to happen.
Is it,
Won't necessarily get a different result, but some people feel that they're going to get more sympathy from a jury than from a judge.
yeah. Just is there an additional cost to the person filing if they ask for a jury?
I don't think so, but I'm not 100% sure on that.
Okay. Um, and Gordon makes a good point. Just so you know, the only way we change the laws in Texas, we talk about it being a landlord-friendly state, and Gordon puts in here um, that there is the apartment association, which is a very powerful lobbying source, contributes to all of the political representatives when it comes time for them to campaign. So you got to know that the only way we're going to change that is for us making our voices heard by advocating for tenants' rights with the people that you vote for and the people that represent you. Please don't ever underestimate the power of a voice, and especially if we get lots of voices talking to the political representatives about injustices that are done on the from by landlords to tenants, and we've got to do that if we're ever going to get it changed.
Thank you. Yeah, thank you, Marty. That's so important, because a lot of times it's not that tenant-friendly legislation isn't proposed. It's that during the legislative session, it never makes it out of committee. So it gets quashed before it even makes it out of committee. So it never even gets voted on by the legislature. So we need to elect more people that care about tenants' rights.
Um, Francis, it's really interesting, but I should be aware of this, and I'm not. Um, and I'm kind of embarrassed to say that, but the process to evict someone from a care facility, from a nursing home or assisted living facility, is that process any different? I know there's discharge planners and there's all sorts of things that go on, but is there laws that prevent them from just going through the eviction process like a landlord does?
They have a process too. I just don't know the different steps, but they have to go through steps as well. So one of the other things I wanted to mention is, one example of how, we can make changes. There actually was a law that was passed in this last session that now prohibits homeowners associations cannot tell their owners that they cannot rent to housing choice voucher recipients. That's illegal now, according to this new law. And it was passed in April at the legislative session, and it becomes effective September 1st of this year. So, for example, if you have, a large condo complex and it's, all individual owners of the units and they have a homeowners association, if somebody wants to then rent their unit out, so they move somewhere else and rents their unit, the housing homeowners association can't prohibit them from renting to a housing choice voucher recipient.
Maria, Gary, and Nelda, I see all of your hands are up. If you would put your comments, and I know I've seen some of them. If you put your comments in the chat or email, I'm sorry, the chat or the Q&A, that's what we're addressing. We've just got too many. There's 200 people on, and so it's just too many people to start open up the mics. I'm sorry.
So I'm reading that question again, Marty, of the when is the judgment released, or so I might understand it a little differently now. So say you got a 3-day notice, and on the 4th day they filed an eviction, right? And somehow, you know, if it was non-payment of rent and you come up with the funds, you go to the landlord, they accept the funds and say, okay, you know, just disregard the eviction. Okay, that's disregard the eviction. That's not good enough. They do need to file to dismiss the eviction. And so, you know, you need to make sure that that happens. And, you know, not getting around to it means that if it still has a court date and they don't dismiss it before then, you will still have to appear in court and tell the judge that you paid the rent and the landlord said they were going to dismiss it and didn't. So if they say they're going to dismiss it, and that's the same as releasing the judgment, they're going to dismiss the eviction. I think that's what you mean anyway by releasing the judgment. So they don't mean the same thing, but I think that's what you mean. But in order to get it dismissed, you know, get that in writing that the housing provider was going to dismiss it. So if the court date moves forward, you have something to show the judge so they do dismiss it, you know, or ask for a copy of the dismissal paperwork that the housing provider filed, or you can just keep calling the court and asking if they filed the dismissal. But again, if they didn't file to dismiss it, it's going to move forward and you're going to have to, you should appear at that court date. Otherwise, you know, the judge will move forward. And, you know, if they said they were going to dismiss it and didn't, and if they don't show up to court, but you do as the tenant, you'll be able to get it dismissed. And you want to make sure you do that because, you know, even by mistake, if it all moves forward, it could get on your record if it was never dismissed.
It would be much more difficult to deal with down the line. Yeah.
Yes.
Grace asks, referring to the possible defenses slide that you had, if a person is receiving housing assistance through HOPWA, are landlords required to notify anyone other than just the resident? And I think this is pretty much the same question as the PHA. They should, but do they have to? I think is really the question.
Yeah, if it's HOPWA, because those are really HOPWA, those are housing choice vouchers too. So yes, yeah. They need to inform them as well.
And is that a requirement, or they should? They should.
Oh, that's a requirement. So if you're getting any kind of housing subsidy, the entity that's giving you that housing subsidy has to be informed of what's happening.
So, and they need to be informed by the landlord, or is the tenant required to inform them?
The landlord.
The landlord. I just want to make those clear. Okay.
Somebody asked, can the eviction judgment be placed on your record during the appeal process? It could. So if you lose the initial eviction, and even though you file an appeal, that can still move forward and become a part of your record. And then after the appeal, if you win the appeal, you need to make sure that it gets removed. So you'll have to have the documentation that you won the appeal.
Someone asks, is there a standard fee for the appeal process, or does it vary by county?
I think there's a standard fee. I think it's the same in all the jurisdictions. but I'm not
Mindy
100%
asked us,
positive. I'm not 100% positive. So
okay,
that's something you could probably, whatever court you end up at, you can probably, or whatever court area you're in, you can just look up that court for their fees.
uh, Mindy asked, does a tenant have any advance notices of the date they can be removed, or should they just assume it will be 6 days after the judgment?
It's going to be a little bit more than 6 days because it's not until that 6th day that the landlord can get an order for the constable to remove you, and then it has to go on the constable's schedule, and it's not going to go on that day. I don't know, it depends on, again, how impacted the constables are in serving these things, but it won't be that 6th day because it doesn't happen same day. It'll happen after that. But again, I don't know the time frame for that. So it really depends on a lot of factors.
I think you answered this, but Monica asked, is there a legal help available for tenants who are facing eviction? And you can call for advice, but I think Francis said earlier, there's nobody I don't think there's any agency that really will go to court with you because they're just shorthanded. Is that correct, Francis? I think you said that earlier.
Yeah, that's right. I mean, once in a while, legal aid will take a case, but it's usually because there's some sort of novel issue and they want to be involved in it. But for your run-of-the-mill eviction, it's going to be really hard to get somebody from legal aid to represent you in court. But like I said, you can go to one of their clinics and, at least arm yourself with what you need and the knowledge that you need to be able to go to court.
And we also do clinics on, we do our clinics virtually every month too, in addition to these webinars. So you're more than welcome to join ours as well, right?
Yes. Yeah, like if you're going through an eviction and you want to talk to us, like Marty said, we have an online clinic, and at the clinic, people get to, part of that is you get to ask questions directly and get your answers to your specific questions or your specific situation. So somebody asked, what happens if a lease is still active and the individual on the lease passes away? Now, for the standard lease, there usually is a provision that says you're authorizing somebody, an emergency contact, to deal with stuff if something happens to you. I remember that when I first moved to Texas because I had to put my sister's info on my lease. So, that may be part of a standard lease to do that, and that would be what happens if someone passes away. So, the housing provider should get in touch with whoever that emergency contact is to, kind of tie up the tenancy, move the belongings out, things like that. But, if somebody passes away, that ends the lease. So no one else should be financially responsible for it. There just has to be someone who, can remove the belongings and things like that.
Someone asked us, is there financial assistance opportunities for tenants who have to pay court or attorney fees and can't afford it? I don't know of any. I can tell you that that it's even incredibly difficult to get financial assistance for rent right now. And I think all the agencies I know of would reserve paying the fees, using the money for rent and not for defense fees. Is that correct?
Yeah,
Francis?
so maybe the person can clarify a little bit, because you can get a waiver from a filing fee in court. So if you're low income and you get the certification, and the court has a document that you have to fill out, where say you want to file a small claim in court, you can ask for a fee waiver of the filing fee. So in that sense, if you're low income, you could get that. But as far as like, attorney's fees, or, if you get stuck in an eviction and your lease said that if that happens, you have to pay the landlord's attorney's fees, there's no programs out there that I know of that would help you with that.
Daniel asked, what happens if the landlord locks the tenant out, changes the locks? and locks them out and won't let them have access. The landlord is required to have someone available with that key to let the person in. They can change the locks, but they have to let
Yeah.
the person in. Is that correct, Francis?
Yes, that's correct, Marty. And there's a whole provision in the Texas Property Code about that. And they can change the locks, but they have to tell you how you can get a key and to be available to let you in if you need to be let in. So
yeah, they cannot refuse to let you in the apartment. How does someone go about I don't know, reporting a landlord or doing stuff if the landlord does refuse to let you in?
So, that's the thing. There's not an agency or an entity. There's not like an administrative body that oversees the landlord-tenant relationship. So, we hear all the time that landlords illegally lock tenants out. So, because Texas doesn't have a lot of laws for the landlord-tenant relationship, most times if the tenant wants recourse, they have to file a claim against their landlord in Justice of the Peace Court. So you would have to file a small claims lawsuit in JP court, and you can represent yourself. And you would have to quantify how being locked out, what kind of damages that caused you. Because, if you say, for example, you couldn't get into your apartment and you missed a day of work, or, you ended up having to move and your moving expenses and things like that. That's really your only recourse if you get illegally locked out, because there's no governing body that's going to tell the landlord that what they're doing is illegal. But you can be your own advocate, and you can pull down the property code about lock changing and maybe, give that to the manager, landlord, whoever, to show them what the law says and what they're doing is a violation of that law, and try to do some self-advocacy.
This is also talking to your political representatives of how do we change the law to include a reparation or whatever you call it, that you can, when you go to court, if they did this to you, they should automatically have to pay you so much, $500 or something like that. But those are things you got to advocate for, guys. You got to advocate. Okay. I know I've got a long way to go on some of these.
So somebody asked, is it correct that an eviction does not end up on your credit report? Does the landlord have to report to a credit reporting agency of your delinquency? Yes, there's a way though that, oh, did I do that?
It's all right.
Sorry.
That's all right.
There's a way that, there's a way they can find out if you've been evicted before, separate and apart from your credit report. But your credit report, they have to file paperwork to put something on your credit report that you owe them any kind of money.
Okay, I'm going to go ahead and go over since we're right at 11:30, I'm going to go ahead and go over the CEU requirements one more time real quick, because I know people have got to get off. For those of you that are looking to get CEUs today, we're providing CEUs for licensed social workers and licensed professional counselors within the state of Texas. That's who we're set up for. If you have a different license in Texas, or you have a license outside of Texas, you're more than welcome to go through the process, get a certificate, submit it to them. But just know there's no guarantees that they're going to accept it, and there's nothing I can do to help you to get them to accept it. You can also get a certificate of attendance going through pretty much the same process. Today's webinar was worth a 1.5 hour of CEU credits. You must have completed the entire webinar and the Q&As, in other words, stayed here the 1.5 hours in order to qualify. You must also complete the Google survey evaluation form. That should give you the opportunity to go to that as you close out of Zoom today. But if it doesn't, you will receive a follow-up email from me with that link, along with a link to the PowerPoint slides for today's presentation and for links for upcoming webinars we have scheduled. The survey will be available to you for 1 week till the 5 p.m. on the 7th. And then please give me till the 28th to get those certificates out to you. That does take us a little bit to get those out. So thank you for joining us. But Francis, I don't know, is there something else? And then please join us. Our next webinar will be on September 27th. Please not only join us, but help us spread the word. It's going to be on tenants' rights, security deposits, repairs, and late fees, and more. And so please help us get the word out and join us for that. A link to register for that will be in the follow-up email as well. Francis, did you find some more you'd like to address?
I did not, but I want to encourage everybody to visit our website, northtexasfairhousing.org, and sign up for our newsletter, because we're going to kick off a new newsletter, hopefully going to do it monthly. And that'll be another way for you to, find out what's going on and if there have been any changes in the law, for example, or, events that are upcoming.
And please know the importance of advocating for change. If we're ever going to get the laws changed, it's going to require us to work on advocating for those changes. There's a lot of things that go on out there that are, and like Francis said, there's no really jurisdiction you can go to for a lot of the things. So there's got to be ways that that things can be changed so that landlords don't just ignore these, even the laws that are on the books.
Yeah.
Well, Francis, thank you so very much.
Oh, thank you. And anybody who has another question that we weren't able to get to, or something comes up after, you'll get my email address. You can email me. You can also go to our website, and there's actually a form on our website to ask a question.
Perfect. Wonderful. And again, Francis's contact information will be in the follow-up email as well. Thank you all so much for joining us. No, we also have our clinic and this webinar both in September. The links to both of those will be in the follow-up email. Thank you all for joining us, and I hope you all have a wonderful day.
Thank you, Marty.
Take care. Thank you, Francis.